What you're about to witness isn't just another routine court appearance. This is where small decisions collide with legal consequences, where explanations meet scrutiny, and where judges are forced to separate excuses from accountability in real time. Courtrooms are often misunderstood. Many assume dramatic verdicts happen after lengthy trials. But in reality, some of the most critical moments unfold during procedural hearings, bond discussions, and violation reviews, exactly like the ones you're about to see. In today's session, two separate defendants stand before the court, each facing a very different problem, yet both tied to a single theme: compliance. One case centers around repeated alcohol violations and disputed claims of responsibility. The other revolves around a tether incident, communication failures, and a judge clearly unconvinced by the narrative being presented. Pay close attention because these hearings move fast, but the implications are serious. Every statement matters. Every inconsistency matters. And most importantly, every ruling carries real-world consequences that extend far beyond this courtroom. Let's step inside.
Court calls case People versus Floyd McCall. McFall, excuse me.
Good afternoon, Your Honor. Constable based on behalf of Mr. McFall, who is present to my right. Can you state your full name for the record, please?
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Mello.
Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people.
This is where the hearing subtly shifts from a routine procedural matter into something far more delicate. The defense is framing the violations as misunderstandings, attempted self-surrender, confusion about warrants, and a request for a scram tether as a safeguard rather than punishment. Strategically, this is an appeal to judicial discretion, essentially saying, yes, mistakes happened, but they're manageable. But here's the legal tension. Bond conditions are not casual suggestions. They are court orders. When violations involve alcohol monitoring, multiple dates immediately raise red flags because they suggest patterns, not isolated lapses. Judges don't just evaluate whether a violation occurred, they assess reliability, credibility, and future risk. Notice the language carefully. The defense emphasizes intent and cooperation. The prosecution emphasizes repetition and concern. That contrast often determines outcomes. So ask yourself, should attempted compliance outweigh repeated violations, or does the pattern itself become the deciding factor?
Your Honor, we have concerns about involved like I would note that it's not just one incident, it's on 2 different days, and that the report of the case when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
And so, Your Honor, part of the reason that we find it concerning, believe that alcohol related involved with this, and that as far as the felonious assault charge, the weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that this one qualifies with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions.
Now observe the dynamic forming. The defense is leaning heavily on narrative mitigation, church involvement, signing up for AA, expressions of effort. These are classic stabilizing arguments designed to humanize the defendant and reduce perceived risk. And to be clear, courts do consider rehabilitation efforts. However, timing becomes crucial. When corrective actions occur only after violations or warrants, judges sometimes interpret them less as proactive responsibility and more as reactive damage control. That distinction can be decisive. Also note the judge's questioning pattern. Short, direct, minimally emotional. This usually signals skepticism rather than persuasion. Judges often test not just facts, but consistency and personal accountability. When answers appear uncertain or unsupported, confidence erodes quickly. From a legal standpoint, bond revocation is not about punishment. It's about perceived inability to comply with release conditions. The court's core concern becomes simple. If released again, will the violation stop? That single question often outweighs everything else.
Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He signed
He's
up.
working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded.
Next case on the docket.
Court calls case of the people versus Megan Moses.
That's about people.
Good afternoon, Your Honor. Constable Bates on behalf of Ms. Megan Moses, who was present to my right. Can you state your full name for the record, Ms. Moses?
Megan Moses.
All right, go ahead.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor.
Address that.
As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal. So she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in and
have a broken phone too. I had my number to the tether guy in my phone and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it poked.
This exchange is a textbook example of how technical violations evolve into credibility examinations. The issue is no longer just the tether. It's the sequence of actions that followed. Courts understand that devices malfunction, accidents happen, and communication barriers exist. But what judges closely evaluate is response behavior. Did the defendant act immediately? Did they contact the appropriate authority? Did their story remain internally consistent? Notice how the judge drills into practical details: who was called, when contact occurred, how many days passed. This is not casual curiosity. It's a structured reliability assessment. In tether cases, delays in reporting are often viewed as highly suspicious because monitoring systems are designed to trigger rapid compliance responses. And here's the subtle courtroom reality. Even reasonable explanations can collapse if timelines appear vague or contradictory. Precision matters enormously in legal settings.
Like there's something poking
Did
through
you
it.
call community corrections at any point?
That's what I'm saying. I was able to, I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my
Was
phone.
your tether
which
going
was
off?
broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as well, not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So if you didn't know where to call, what were you gonna do with her phone?
I was gonna call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him, and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went
Well,
off?
it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to the community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle, or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well. Like I'm not trying not to.
She's not trying to
She's not
trying to abscond, Your Honor. She's not trying to disobey the court orders. It seems it was just an accident. And just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So.
Yes, but I don't
have a
understand why she didn't.
She hasn't even secured a ride back yet today, so
Yeah.
her transportation.
But why she didn't keep in contact more with community corrections?
I think it's due to
I mean,
her
this
lack
thing
of.
went off almost 10 days ago.
Well, I was
and
waiting.
We don't.
I'm sorry.
Go ahead.
Apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure, and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this point.
I don't.
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So so the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI 3rd, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people, and something I picked up on. I think the court picked up on it too, as
I did.
So I'm just worried about what's going to happen.
I don't think I'm being told the truth, in all honesty.
The prosecution's argument here targets something incredibly powerful in court: inconsistency, not dramatic evidence, not forensic proof, simply conflicting statements. Courts frequently interpret changing details as indicators of credibility risk, especially when violations are involved. The prosecutor highlights the "called my mom" versus "went to her work" discrepancy. On the surface, that may seem minor. Legally, it's not. When judges suspect a narrative is evolving under questioning, trust deteriorates rapidly, and bond decisions are heavily trust-based. There's also a deeper legal principle at play. Bond is conditional liberty. Compliance is not optional. If the court believes information is incomplete or unreliable, revocation becomes far more likely regardless of sympathetic circumstances like transportation struggles or anxiety claims. This moment isn't about technology. It's about believability. Would you view these inconsistencies as nervous mistakes or warning signs?
I understand.
Your Honor, I understand, but as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th, 2025, 9 a.m. Defendant's bond is hereby ordered revoked. Defendant's remanded.
2 defendants. 2 very different stories. Yet both outcomes hinge on the same judicial calculation: confidence in compliance. Courts operate on risk management, not emotion. Repeated violations, delayed reporting, and inconsistent explanations all directly influence whether a judge believes future rules will be followed. What's striking is how quickly these decisions unfold. No dramatic trial, no lengthy testimony, just credibility, conditions, and judicial discretion shaping life-altering consequences within minutes. And this is precisely why courtroom proceedings are so revealing. They expose how law functions in real time, unscripted, analytical, and often unforgiving toward uncertainty. If you found this case as fascinating as we did, make sure to hit that like button. Share your perspective in the comments. And don't forget to subscribe for more real courtroom breakdowns and legal drama. Every hearing tells a story, and we're just getting started.